Ma'am, let us discuss about the petitioners within the US and outside the US.
Okay.
For example, the petitioner is already in US and he is already in F-1 or L-1 or H-1B, and how they can do this adjustment of status, and next, what are all the benefits if they do this AOS?
Okay, wonderful. That is the most attractive part of this RIA, the Reform and Integrity Act. So, just to give you a little bit of context, before 2022, we could not file adjustment. We had to first get our 526 approved, the investor, as I said, to be called a bona fide investor.
Okay.
We needed to have that approved, and then we could file an adjustment of status or request the consulates to give us the immigrant petitions. After the RIA, after the Reform and Integrity Act, the government allowed us to do concurrent filing.
Okay.
Concurrent filing means you can concurrently file for the benefit. We are assuming that our 526E will be approved because we are filing a good petition. Our source of funds is great. Our project is wonderful. And we are assuming it will be approved. We concurrently file for the benefit that is due to us, which is we want our permanent residency. So the USCIS allowed us to file it concurrently as long as the visas are available. That means the category is current on the visa bulletin.
Okay.
Ours is a small conversation today, so that's yet another topic. There is a visa bulletin which is released every month, and where the government tells us how many visas are available in any particular category. So right now, EB-5 is current. Government allows us to do concurrent filing, so we can do the filing for the adjustment of status.
Okay.
Adjustment of status means I am on an H-1, I am on an F-1, I am on an L-1, P-1, any visa, a legitimate status, a legitimate non-immigrant visa status, and please change my status to that of a permanent resident because I'm filing this investor petition, which will be approved, right? That's what we are essentially trying to say. So when the category is current and we are living in the US on a non-immigrant visa, we are able to concurrently file for our adjustment of status. When we file for adjustment of status, by law, if I am on H1 and tomorrow I filed my adjustment of status, what is the big benefit there apart from getting permanent residency, which we are seeking? The big benefit is that tomorrow, as soon as I get my receipt notice in hand, I am living in the United States without the fear of accrual of any illegal presence. I can leave my job, I can stop my F1, I can stop any other visa status. I came in as a P1. I don't want to work as a P1. I don't want to be the O1 today. We can now stay without having a different status. It does not have a category, but it is just waiting for adjudication, but not accruing any illegal presence, which is a huge benefit because that fear, the sword that hangs on most people who are on any non-immigrant visa is that tomorrow if you have an argument with your employer or something goes wrong, your health doesn't allow you to work, what are you going to do? Are you just supposed to leave the country and go back? Your kids are in school. So many little things are tied up to every individual. So filing an adjustment takes that away.
Okay.
Now, the second huge benefit of filing an adjustment of status is that we have allied benefits. When we file a proper adjustment of status, and by proper we mean grounded in law. So, when we file for adjustment of status, we can also file for what is called the employment authorization, which is an allied benefit of filing adjustment of status. And we also file for what is called the advanced parole.
Right.
In simple words, parole is when you are accepted in, paroled in without any problem. That yes, your status is good, you can come back to the country. Advance is beforehand. So the government is saying, we are saying, if you travel with advanced parole, you can come in without any problems. In simple terms. Of course, everything has complexities at the end of it, but we are just trying to simplify it.
Yeah.
So those are the great benefits of filing concurrently, that of course, our 800,000 is going to give us permanent residency tomorrow, but that could be 2 years, 3 years. But filing concurrently for adjustment gives you the EAD and the advanced parole, and the fear of being in the country and having any issues is also elevated.
Okay.
Right?
Okay. And what about for the petitioners who are outside the US?
Okay, so the petitioners who are outside the US, there's nothing like adjustment for them, right?
Oh,
They
yes,
cannot adjust.
yes.
Adjustment only means we are adjusting from one status to another. But if you're outside the country, say you are wherever, in India, let's assume India, then you would file your investor petition. And from there, once the investor petition is approved, the USCIS informs the National Visa Center that the petition is approved. National Visa Center does a few more formalities, and from there on, it sends your approval in all your documents to the US consulate in your home country, whichever is your closest consulate, and there you stand in line for an immigrant visa appointment. You get your appointment, you get your permanent residency, and you come in.
Okay. And what about for dependents, spouse, kids?
Okay, so for any US visa, we always have, other than B1, B2, to correct myself, that is a visitor's visa, which is individual. But for any US visa, every primary applicant has the benefit of having their family with them. And by family, you mean your spouse, which could be husband or wife, and your children who are under the age of 21.
Okay.